Says Michael Popok, Legal AF, with breaking news. Donald Trump's lawyers, particularly Alina Habba and her partner, have screwed up again and almost allowed the transcript of their client Donald Trump in the E. Jean Carroll civil rape case to be automatically disclosed to the public this morning because they missed a deadline. Let's back up. E. Jean Carroll has a case for civil rape and for defamation. In her allegations filed in federal court in New York, she claims that in 1995 or 1996, while she was shopping at a department store called Bergdorf Goodman's across the street directly from Trump Tower, she bumped into Donald Trump, and within an hour or so of hanging around with him in the department store, he eventually pushed her into a dressing room and raped and sexually assaulted her, to the point where she claims the only way she got him off of her was to knee him, use her knee to get him off of her. She's even saved evidence of the crime in the form of a dress that allegedly has DNA evidence of Donald Trump. She originally, Jean Carroll, filed that case with her lawyer extraordinaire Roberta Robbie Kaplan in or about 2020, alleging that President Trump defamed her when he was president by claiming he didn't know her, that she fabricated the story, and in his misogynist comments, she wasn't his type. He then did it all again when he became ex-president on his social media platform, giving rise to another count of defamation. But in November, New York recognized that adult survivors of sexual assault and battery and civil and rapes in this case, even if their statute of limitations had run on their claims, criminally or civilly, could bring within a 1-year window their claims as adult survivors. E. Jean Carroll is 79 years old now, and she brought the claims under the Adult Survivors Act on the first day she was allowed to bring those claims. There are depositions that have already taken place of Donald Trump and, of course, E. Jean Carroll. It looks like Alina Habba, based on the transcript, with all the mastery of law that she has, took the deposition of E. Jean Carroll and, in really disgusting fashion, asked her questions that you are not supposed to ask a rape victim. Why didn't you scream during the attack? And asked her about her emotional distress, and got into some very intimate details that were unnecessary even to defend the case. But then again, that's what we understand from Alina Habba. Donald Trump's deposition was taken in November or December by Robbie Kaplan. And all of that, excerpts of that transcript, had been marked confidential and sealed, subject to the orders of the court. Well, Robbie Kaplan filed a motion to have the Trump section of the deposition, 34 pages or so, released to the public. And it was sitting with Judge Kaplan, no relationship to Robbie Kaplan, Lewis Kaplan. It's been sitting with him for a while, and he gave Alina Habba and her partner, Michael Popok, one last chance to argue why he shouldn't take the seal and the confidential stamp off the deposition transcript and release it to the public. Because there is a general presumption that proceedings in the courthouse will be public and sunshine and transparent, and very few things are ever sealed, and certainly not in civil context, and just regardless of who's your defendant, in this case Donald Trump. But they missed the deadline. Robbie Kaplan gave them the required 3-day notice, required under Judge Kaplan's rules, to oppose the unsealing of the transcript. Couldn't be plainer. She put them on letter notice, written notice, that pursuant to the judge's rules, we call them the chamber rules, the rules of his chamber, that they had to file something in opposition. And 72 hours went by, and on the 9th of January, in the morning, Judge Kaplan signed a 1-paragraph order saying, having heard no opposition from the defense, I'm going to unseal this, and directing the clerk of the court to put them on the docket so that the media and everybody else can take a look at these 34 pages of Donald Trump testifying. And he won't be able to assert the Fifth Amendment, so there's going to be some real testimony in there that we really haven't seen before from somebody like Donald Trump in his cases. Really valuable stuff, not just for this case, but the other cases that are around the country, including the civil fraud case. Why was that transcript even filed, you might be asking? Because There was a fight in the courthouse in December between E. Jean Carroll's team, led by Robbie Kaplan, and Donald Trump's team, led by Alina Habba, over whether the new Adult Survivors Act civil rape case claim would just be added to the existing civil defamation case, because it arises out of the same set of facts. It either happened in the Bergdorf-Goodman dressing room or it did not. The jury has to hear the same exact facts and then get to the defamation in 2019 and 2021 and 2022. So those were the issues. And the judge had already set the trial and has the trial on his docket for the defamation case for April of this year, which is really a short time away. It's 4 months away. And of course, Alina Habba is never ready. And neither is Donald Trump. So she jumped up and down and said, we need more time. The civil rape claim. I don't even know who's going to be representing him in that. And so on and so on. And the judge, as I had reported earlier, wasn't having anything about that and said, stop. These seem to be overlapping facts. I'm going to keep these cases together. And I think I'm going to have them tried together in April. There's still a motion to dismiss pending about the civil rape claim. But I assume, based on prior comments by the judge from the bench, he's not going to dismiss the case. And I predict that both cases, the civil rape and the defamation case against Donald Trump brought by E. Jean Carroll, is going to go to trial simultaneously in front of one jury in April of 2023. In order to argue for that to happen, to have a consolidated case in April without delay, E. Jean Carroll's lawyers filed a motion with the judge and attached Donald Trump's 34 pages. Now, it was blackened to the public. It was redacted to the public, but it was filed under seal, or what we call in camera, with the judge, so that the judge could review it in all its glory and all of its infamy without having to be bothered with black lines. Judge got the real copy. Public got the blackened copy. The fight now is to have the unredacted, the same thing that the judge saw, the real 34 pages of Donald Trump transcript testimony, deposition sworn testimony, go to the public. And they just barely missed effing that up, Alina Habba. This is what happens when you hire lawyers who are over their skis and over their heads and can't handle a case like this. This is not going on Fox News or some other friendly right-wing media outlet. This is trying a case, a complicated case, in front of really smart people in federal court in New York. Donald Trump has chosen Alina Habba to handle that, someone who had no reputation for handling sophisticated litigation, let alone dozens of them anywhere in the country. And she's already got herself sanctioned a number of times in representing Donald Trump. And constantly, her number one thing seems to be arguing with judges. She almost got sanctioned again by Judge Engeron in a simultaneous case that's going on down the street in the New York State Supreme Court case over the $250 million civil fraud claim brought by the New York Attorney General, Letitia James. All that apparently Alina Habba does is try to spar and argue with the person wearing the black robe, cutting him off, not letting him finish his sentences. I mean, these are taboo cardinal sins for a lawyer in a courtroom. And I should know because I'm a lawyer in a courtroom on a regular basis. But this seems to be her MO. Here in federal court, she had to beg and plead. Apparently, the judge had a small typo, a little technical typo in the order that gave them the 3 days to oppose the unsealing. The order should have said the defendant has 3 days, 72 hours, and if I don't hear from you in 3 days, I'm going to unseal the deposition transcript. That's what Robbie Kaplan, the lawyer for E. Jean Carroll, also put in her letter and her filing with the court. But when the court and its clerk prepared the order, there was a typo. It said that the plaintiff shall have 3 days, which made absolutely no sense because the plaintiff was seeking to unseal and have the document, the deposition transcript, be made public. So why would the plaintiff have to respond in 3 days to that motion and the relief that's being sought? Only if you completely can't read would you have not realized that there was a typo in the judge's order. And what do you do when there's a typo in the judge's order? Because it happens occasionally. Or there's lack of clarity, or there's the judge kind of forgets something that already happened. So you immediately get on the phone, both lawyers, with the judge's law clerk, because you don't normally get to the judge, and you say to the judge's law clerk, we think there's a typo or an error in some sort of infirmity in the order the judge has issued. Can we get the judge on the phone, or can you bring it to the judge's attention? Or you file a letter brief or a letter, which you can do in the Southern District of New York, and you could put the judge on notice, Your Honor, we received your order. We are confused. Did you mean plaintiff or defendant? Please advise. Respectfully, signed, Alina Habba. She doesn't do that. So she completely abdicates her responsibility as an officer of the court. No surprise. Lets the 3 days pass, and then the judge enters the order. Well, they get a copy of that because if you're a member of the federal bar, in this case, Southern District of New York, you get an electronic copy of whatever is filed by the court or entered by the court as an order immediately in an email. Boom, in one of your cases. It says case number, and here's the event, and you open it up. And I'm sure they opened it up and they crapped their coffee cup. I said, oh God, they're about to release the transcript. So they got around to dashing off a letter and communicating with the court. And then the judge smacked his forehead. This is my artist rendering. Smacked his forehead and said, yeah, I think there's a typo in there, even though they knew or should have known I meant defendant. But it technically says plaintiff, and I don't want any error built into the record. So I'm going to handwrite and sign that I'm going to give them a new 3 days starting from today. So they have now, Alina Habba, her partner, and Donald Trump have until Thursday to tell the judge why, under the body of law that is in favor of unsealing all transcripts, why these 34 pages have to remain sealed. Given the fact the judge already unsealed, and they wanted unsealed, Trump's side, the deposition transcript of E. Jean Carroll with all of the very intimate details about her sex life, about her sex history since the incident all the way till today, her relationships, the really tragic events, emotionally damaging events that happened to her, as she alleges, in the dressing room. They released that. Of course, Donald Trump wanted that out in the public for his fans and followers. So what's good for the goose is good for the gander. So now his transcript, I don't see any legal basis in public policy or law that would allow the judge to continue to seal the 34 pages of Donald Trump's transcript, especially given that the victim, the plaintiff victim, has already had her deposition transcript unsealed and has been out in the public. So to balance those inequities, to balance it, make it more symmetrical, the judge is going to grant, I believe, the motion without delay, going to reject whatever Alina Habba and her partner file, will report on that filing when it happens, and then I'm sure later that same day, because he's been sitting on this decision for quite some time, Judge Kaplan is going to rule in favor of E. Jean Carroll, and we're going to get our hands on the 34 pages. And I don't think there's going to be much, or if any, assertion of the Fifth Amendment to protect Donald Trump and prevent him from testifying, because there is no criminal prosecution that is possible against him, because that statute of limitations, which is different than the civil one related to her civil rape case, has already run. No prosecutor could bring a criminal rape case against him based on events that happened in 1995 and 1996 in the state of New York. A person can bring a civil claim against it if they were the victim during the next year until November, while the window is open based on the passage of the Adult Survivors Act in the state of New York. That is the major difference. Without a possibility of criminal prosecution, you can't assert the Fifth Amendment. You have to have a reasonable good faith belief that you will be incriminating yourself in the context of a criminal prosecution. This is why federal judges often, encourage prosecutors, Department of Justice, to give immunity to a witness who is asserting his Fifth Amendment privilege. Because once immunity is given and the person cannot be prosecuted, they can no longer assert the Fifth Amendment privilege either, because they're not subject to criminal prosecution. So I want to clarify that, because some people think kind of on the street that you can just assert the Fifth Amendment privilege whenever you want. In a civil context, you can only do it, as in a criminal context, if you have a reasonable fear of a criminal prosecution. If you have immunity or a statute of limitations has run, so you have no fear of real prosecution, you cannot assert the Fifth Amendment. And I'll end it with this. If you assert the Fifth Amendment in a civil context, whether it's Donald Trump asserting the Fifth Amendment 444 times in the $250 million civil fraud case brought by Letitia James, New York Attorney General, where he took the Fifth in response to every question other than his, what is your name? Literally. Or you do it here. You tried to take the Fifth Amendment here, which he's not going to be able to, because there's no, in the E. Jean Carroll case, there's no ability for him to be prosecuted. That would be, the jury would be instructed to make an adverse inference against the person taking the Fifth Amendment in a civil context. In a criminal context, it cannot be used against them in a court of law. In fact, the jury will never know about the Fifth Amendment assertion at all. And of course, the defendant never has to take the stand in the Fifth Amendment because he can't be compelled to testify against himself. Not so in a civil context. In a civil context, if you took the Fifth Amendment, the jury gets to be told that in response to these 400 questions, for instance, Mr. Trump asserted the Fifth Amendment. You, jury, you are to make an adverse inference, meaning if he was asked, are you inflating the value of your properties improperly in order to obtain more money from banks, and he says Fifth Amendment, you can assume that the answer to that question is yes. That's the adverse inference. So it's just assume yes to all the questions about whether he committed a crime or not in the civil context. Don't have to worry about that in the 34 pages that's going to be coming out of Judge Kaplan's courtroom related to the deposition of Trump for what he did to E. Jean Carroll as alleged in her suit, because he cannot be sued, he cannot be prosecuted, therefore no Fifth Amendment. So let's wrap up. E. Jean Carroll and her trial against Donald Trump for civil rape and defamation are going to trial in April of this year, federal court, Southern District of New York. The issue right now is whether his deposition transcript, 34 pages of it, unredacted, is going to be released. And because his lawyers, including Alina Habba, screwed it up, the judge gave them one more chance until Thursday to file an opposition paper. But even after that opposition paper is filed, I'm reasonably confident that Judge Kaplan is going to release to the public the 34 pages of Donald Trump's testimony, and we will report on it when it happens. This is Michael Popok, Legal AF reporting.
At MeidasTouch, we are unapologetically pro-democracy, and we demand justice and accountability. That's why we're spreading our message to Convict 45. That's right, gear up right now with your Convict 45 tees and pins at store.meidastouch.com. That's store.meidastouch.com.